with stare decisis. Stare decisis is in the note I gave you. Everything I want to say is from there. Okay? So if you have that note, just go to where we discuss stare decisis there, and you'll be home and dry. So what is stare decisis? How did I define stare decisis in my note? Hello? There is a particular Latin phrase that is used to explain it, okay? Which literally means let it stand, okay? What has been decided should not change. So the principle behind stare decisis, or what we call common law doctrine of judicial precedent, is that judicial decisions, once pronounced, should serve as a guide for future decisions. Otherwise, you are going to have anarchy in the judicial system if courts are at liberty to depart from precedent that they themselves have established. So the practice is that when a case comes before the courts and the courts applying the law as it is arrives at a particular decision, subsequent cases with identical facts, the statutory law remaining the same, must be decided the same way. This is a feature of a common law legal system. In every common law legal system, the courts establish principles that will guide taking decisions in future when facts are the same. Unlike a civil law legal system, where the court merely applies provisions of codes. You have codes that cover in detail several aspects of the law. And all you need to do is to apply the provisions of codes to the facts coming before the court and arrive at a decision. But in a common law legal system, the method of reasoning is not that straightforward. It's both deductive and inductive. Okay? And you find what the principle that you apply to a case is by looking at myriads or several number of cases with similar facts decided before. So after you have arrived at the conclusion that this is what the cases are saying, it is that your ratio that you have found from analysis of the cases that you apply to the dispute before you. Okay? And the reason why that is so is that the common law legal system does not want anarchy of the judicial system. The common law legal system wants it to be possible that you can predict outcome of decision of a case by looking at previous decisions. And that is preferable to a situation where you treat a new set of facts as completely brand new, because you have to establish a new law in each case. So, are we on the same page on what the meaning of stare decisis is? I'm trying to open my notes here, but I don't know what is happening to this, my laptop. Sorry, let me drive to the page where I discuss stare decisis so that we can move forward fast enough. Yes. I started with meaning of the term. Understand that phrase. Stare decisis et non quaeta movere. Let it stand. What has been fixed should not move. Okay? And I said that in an article of mine, uh, I said there that all legal system cannot exist without precedent, whether they have the common law stock or the civil law stock. But in contrast to the common law legal system, the civil law legal system approximate precedent to judicial notice. That is notoriety of a decision on identical facts, not minding the courts pronouncing it. Whereas stare decisis is a function of hierarchy of judicial authority and not of notoriety in a common law legal system. What do we mean by this? In a civil law legal system where courts decide, they also have a system of precedent. But that system of precedent is not based on hierarchy of courts, it's based on notoriety of a decision. If you have been taught customary law, they would have taught you what you call judicial notice. Judicial notice is the rampancy or regularity at which court pronounced on a rule of customary law and its meaning. So you want to see 1, 2, 3, 4 previous cases where idigi has been recognized as an alternative rule of estate distribution known to Yoruba customary law. So that in a fifth case, you say, look, don't present fact on that issue again. We all know that Yoruba do idigi because plethora of cases between Yoruba people have been decided by courts. So that's notoriety. Notoriety. Notoriety would then be based on the fact that many courts have pronounced the same thing before, as opposed to our own system that is based on hierarchy. If you line up 10 Court of Appeal decisions deciding A, but I have one Supreme Court decision deciding B upon the same facts, the law is B, not A. The law is B, not A. Because of what? Because our system of precedent is based on hierarchy of courts. You have to look at the court that pronounced it vis-a-vis the court where the facts, the new facts, upon which you want to cite that case as a reason. Okay? So that is the difference between our own system of precedent and their own system of precedent in a civil law legal system. Then I said in 1932, a jurist was looking at the common law variant of precedent or stare decisis, and he explained that there are three key features. Okay, according to him, every court is absolutely bound by decisions of all courts superior to itself. Okay, a high court judge may not be bound by the decision of another high court judge, but a high court judge is bound by decision of the Court of Appeal and of the Supreme Court. So that highlights what I mean when I say hierarchy is important. A high court judge can only be persuaded by the decision of a fellow high court. Okay? So you have to understand the difference between binding and persuasive precedent. Okay? The second one, as at 1932, when he was writing, Goodhart found that in England, even the House of Lords, that was the apex court as at that time, was bound by its own decision. So even if the House of Lords has pronounced a case and another case comes tomorrow, the House of Lords is not at liberty to say, well, we are the highest court of the land. We can ignore what we decided last time. No, the House of Lords was also bound by its own decision. Okay? And then thirdly, he wasn't sure as at that time, but he said the Court of Appeal is probably bound by its own decision. Okay, we'll see that moving forward, of all those three rules, only one remains. Only the first one, which is that every court is absolutely bound by the decision of all courts superior to itself, remains. What of rule 2? The rule that apex court is bound by its own decision. That rule changed in 1966. Okay? A practice direction. You know what is called a practice direction? Some of the time, the apex court of any country can issue a practice direction, directing her and the lower courts in the future to follow a particular pattern. That's what we call a practice direction. So in 1966, the House of Lords issued a practice direction saying that it was no longer going to be bound by its own decision, and that in deserving circumstances, he can revisit his own decision and let me answer this call. Hello? 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 Are you people hearing me?
Yes, yes, yes.
Okay, I just want to be sure.
Yes, sir. Yes.
So in 1966, the English House of Lords issued a practice direction to the effect that it can now overrule itself. It can now overrule itself. And most common law countries have followed that practice. In Nigeria, beginning with the 1971 case of Johnson and Lawansi, we have seen that the Supreme Court occasionally, it's not something that the Supreme Court does all the time, once in a while, the Supreme Court would listen to people who come and talk to the Supreme Court that, sorry, sirs, your decision in so case was probably in error. Please listen to me, persuade you to change that your decision. The Supreme Court, the Nigerian Supreme Court does not treat it as a, the Supreme Court treats it as a very serious matter. And there is a practice that when you want the Supreme Court to overrule itself, you inform it early so that it will constitute a full court panel. Okay? In in second semester where they are teaching you constitution and jurisdiction of the Supreme Court, they will tell you that there are occasions when the Supreme Court must be a full court. Okay? One is when it is when it's exercising its power to determine a dispute between federal and states or between states. Okay? I don't know of the others. There are two others, but it's not our concern in this class. But as a matter of practice, the Supreme Court will also constitute a full court if the Supreme Court is aware that what is before her is a plea that it should overrule its previous decision. Okay? So Nigerian Supreme Court have overruled themselves severally, beginning with Johnson and Lawanson, a 1971 decision. Okay? Go to your textbooks and see how many cases they've given you on Supreme Court overruling itself. Okay? So rule 2 is gone. That the apex court is absolutely bound by its own decision is no longer the rule. Rule 3, Goodhart told you that in 1932, the Court of Appeal is probably bound by its own decision. But in the case of Young and Bristol Aeroplane, 1944, if that rule was in existence in 1932, it ceased to be in existence after Young and Bristol Aeroplane was decided. And the English Court of Appeal decided that there are 3 good reasons upon which it may depart from its decision. First of all, if its decision was later shown to have been overruled by the House of Lords. Secondly, if the decision is found to be par incuriam. And thirdly, if it is in a third case, it finds that there are 2 previous cases of the Court of Appeal that are contradictory, then it has the right to pick and choose. Okay? The Court of Appeal in case A decided Z. The Court of Appeal in case B decided Y. Then there is a case C now, thrown up the same facts. The Court of Appeal is neither bound to decide A, to decide Z nor Y. It would reconsider and pick and choose either of them as its own decision. So that became the position of the law of the rule of practice of precedent since Young and Bristol Aeroplane. There are plethora of Nigerian cases on the option open to the Court of Appeal. There is particularly an article written by our own Professor Iwo on what the Court of Appeal should do when there are conflicting decisions of the Supreme Court, not of its own anyway. But Young and Bristol Aeroplane was concerned with what the Court of Appeal should do when there are conflicting decisions of the Court of Appeal. Okay? So I then went on to look at advantages and disadvantages of stare decisis. I presented them in summary form, but there is an article of mine where I discuss them more in detail. If you like, you can go and see the article. So the key advantage is certainty and predictability. That's very clear to explain that you are able to advise your client on what will be the outcome of a decision based on previous decisions. You can predict. Even though we have a school of thought, the realist school, that says all that is just a deceit, that every case is a law on its own, and that there is nothing certain or predictable about outcome of decisions. Okay? But the advantage that we think that stare decisis can provide is that you are then certain about what will be the outcome of a case. You can predict the outcome. Convenience. It makes it very easy for judges not to go into voyage of discovery every time facts are presented. Once you know that identical facts have been pronounced upon before and the law has not changed, it becomes very convenient for you to adopt what was decided in the earlier cases. 3, you don't want the judge to be arbitrary. You want to provide him with a guide. Providing with a guide simply means that you have a basis for appealing his decision. You have a basis for saying his decision was wrong, because you are able to show that in an earlier case with similar facts, this was what was decided. Okay? Protection of vested rights. Yes. When the court has earlier decided a matter, people will base their advice on that decision. So there will be a vested right or vested interest in that decision remaining the same. If you pronounce against the decision that has been decided before, you will derail the plan of so many people who have wisely based their life on what you decided. Okay? Then it is said to also be an advantage because flexibility is also said to be an advantage. But by the time you look into the details of the rules, there are rules for you to depart. There is distinguishing, and there is a period decision you can show its power in Korea. You can also distinguish the facts and all of that. And so flexibility, flexibility is said to be an advantage. Next, we move to perceived disadvantages. There's nothing that has advantage that does not have disadvantage. The first one is perpetuation of errors. According to Goodhart and a number of critiques, they say that stare decisis makes today's judges slaves to past judges and despots to future judges. That's very clear. It makes them slaves to past judges. They cannot have ideas of their own because some judge had pronounced on the matter before and they must follow it. Then, if they are making pronunciation on a new matter without following any precedent, they then become despot to future judges, because future judges too will not be able to exercise their own discretion. They will be bound to follow what they have decided. Okay. Secondly, it is not a good store of prevailing custom. You've been taught customary law. One of the characteristics of customary law is its flexibility. But that flexibility would also mean that the situation yesterday when the court pronounced a judgment may not be so today. The great Lord Denny, on many occasions, had pronounced judgments that were futuristic. Okay? Futuristic in the sense that he refused to be bound by precedent by saying that, look, the decision that was made at that time was right for that time because these were the underlying facts. But today or in the future, it is no longer to be right. Okay? They will give you the case of Trentex and CBN, where Lord Denny in the Court of Appeal was faced with the task of either relying on President of the House of Lords and throwing the case of Trentex away, or rely on prevailing custom, international customary law, and ignore decisions of the House of Lords and accepting Trentex's argument. Lord Denny opted for the latter because according to him, when the House of Lords pronounced that immunity was absolute, immunity truly was absolute in practice as at that time. But as at the time Trentex and CBN came before him, he looked at English state practice, look at English statutes, English European treaties, which England had ratified, even though it was yet to enact into law, and said the position of customary international law has changed. And so if the House of Lords were to be given the opportunity to pronounce today, it was not going to follow its previous decision that said immunity was absolute. So how do we relate that to this? The criticism said style decisis is not a good store of prevailing custom. Okay? If we want to rely on precedent, the precedent will be based on what the custom was as at that time. But custom, like usage and practice, is flexible, it can change. And so if custom, usage, or practice have changed, relying on pre-existing precedent that upheld what the custom was before is useless. It will not be of help. Of course, Lord Denny was lucky in that case to have been supported by another court of appeal judge, whereas the third court of appeal dissented, saying that no, if there is a House of Lords decision on this matter, and it says this is the way it is, I don't think I have the power to depart from that House of Lords decision. So that is what we mean when we say it is not a good store of prevailing custom. 3, we said judges with prejudice cannot be totally prevented from being influenced by their prejudice. Rely on technicality of the principle of style decisis. This is like
And no, not the cheat on this.
So, as I'm saying, those are the advantages and disadvantages. Move away from there. The two contradictory roles of a judge in the common law legal system. He creates reason when none exists. He applies reason when one created by superior court exists. Then I ask the question, can judges deny the charge of making laws? That's a jurisprudence question. Do judges make law? Judges themselves will never tell you that they are making law. They will say that they are declaring the law as it is. But as the ordinary man, as an American realist, he will tell you that that is not true. Every pronouncement of the court is a new law because there are no two cases that are practically identical in all respects. And what have you? Okay. Now let's go to case law technique and terminology. What is the difference between persuasive and binding precedent? A persuasive precedent simply persuades the court. The court is not bound to follow it. A binding precedent is one that the court must follow. The court does not have a choice. So I gave you Nikitopi's explanation of it there. He said the precedent is said to be binding on an inferior court because it was as a matter of law follow that precedent of the superior court. But a precedent is said to have only persuasive authority if a court has an option in the hierarchy of the court structure, either to follow or reject it. In other words, a court is free to depart from the decision of another court because that decision is not binding on it. So we gave examples. What are examples of persuasive precedents? I said, A, the president of the court cited to another court of coordinate jurisdiction. Okay? You are arguing a case before the High Court at Ikeja. The only precedent you have is a judgment of either the same High Court or of a federal High Court. The judge will tell you that, well, thank you for giving me the thinking of my learned brother, but I am not bound. Okay? But if he has read it and he thinks that his learned brother had done the right thing, said, I am persuaded, okay? I am persuaded by the decision of my learned brother and I will follow it. So he has the option of either accepting it or rejecting it. Okay? So, B, president of an inferior court cited to a superior court. Yes, that is logical. If you cite before the Court of Appeal, decision of the High Court, you are not telling the Court of Appeal that it must follow the decision of the High Court. But the Court of Appeal will look at the reasoning and see that, well, even though I'm not bound by this, I think the lower court made a lot of sense and I will follow his reasoning. So that's persuasive precedent. Okay? What of precedent of other courts? Are we bound by decision of the English House of Lords or whatever? This used to be an issue in the past. But today, all of the Nigerian courts agree that they are not bound by decision of any English court. Okay? I refer you to some quotation. Okay, from an article of mine, I ask, is there a relationship between the binding effect of English decisions and reception of English law? I said it is submitted that there ought not to be. Start decisis is understood at common law as a function of the hierarchy of a court system. This is Obilade's argument that I have lifted. Do you understand? I may not have used his words, but I learned this idea from Obilade's Nigerian legal system. Decisis is understood at common law as a function of the hierarchy of a court system. The weight to be attached to any decision depends on the location of the court, making it in the hierarchy of courts, as compared to the location of the court or to follow the decision in the same hierarchy. So if you are bringing the decision of an English court, where can you locate it in the hierarchy of court in Nigeria? Nowhere. So for that reason, Obilade said, and I agreed, that foreign decisions, whether of English or other court, can never have the status of being binding in Nigeria. Okay? Then I refer you to a case, Adeton and Nigerian breweries, where Akinta GSC accepted that argument that English decisions are not binding on us, they are persuasive. But he made a distinction. He said that some English decisions have already been adopted in Nigeria. So they cease to have the status of foreign decision again. They now have decisions of Nigerian decision, haven't been adopted by our courts. Okay? So read that quotation. You see the point we are trying to make. So if the precedent from English court is of mere persuasive precedent, those of other Commonwealth and non-Commonwealth courts cannot be more than that too. Okay? As a matter of fact, you may likely attach more weight to the decision of English court than the decision of non-English courts. Okay? Then I ask the question, what is the status of the precedent of a court when cited to the same courts? I've already answered that one in my illustration. High courts are never banned by their own precedents. But appellate courts are never banned by their own precedent in criminal matters. See the case of Aaron Taylor. I lifted this idea from Obilade. Okay? But take note that after Young and Bristol aeroplane, they have become banned by their precedent in civil matters, except one, they may overrule if they now know that they made an error. It was given by in Korea. Two, they will depart from it if it was reversed or overruled by the apex court. And three, they will pick and choose if two or more of their precedent conflict one with another. Okay, I've told you this one before. I said, apex court. I told you the practice direction of 1966, and I told you now they consider themselves not necessarily bound by their previous decision, but they do not, it's not the thing they do all the time. And to highlight the seriousness, they want you to tell them early that there is a previous decision of their own that you want them to overrule so that they can constitute a full court. That is 7 justices. Okay? And in the Nigerian cases where the Supreme Court has been found to overrule itself, they have given several reasons for doing so. They have sometimes said, yes, we made a mistake. We gave that judgment power in Korean. Okay? In Georgia and Lawansi, they came out clearly that they gave a previous decision in, I think, Omasanya and Dani Fuwoshi power in Korea. Okay? Two, sometimes they say they were clearly in error based on the law. Thirdly, they will say their previous judgment may have been contrary to public policy, or is occasioning miscarriage of justice, or is perpetuating injustice. The important thing is that they will find something to say is the reason why they are overruling themselves. But you will find, shockingly, that what usually happens is that they do not even address that they are overruling themselves. They just give one judgment that cannot stand with the previous one. That's where we now have the problem of conflicting decisions, which at your level, I don't think I want to go into it. Okay? Okay. So now let's look at terms. What is the ratio decidendi of a case? When we say a case is binding, it's not everything about that case that is binding. It is the ratio decidendi of the case. The plural of ratio decidendi is ration decidendi. Okay? Ratio decidendi simply means the principle of the case. Supreme Court defined it in Dalatu and Turaki. Say it is, however, the principle of law upon which a particular case is decided that is binding. Such a principle is called the ratio decidendi. A statement made in passing by a judge which is not necessary to the determination of the case and is not a ratio of the case, but an obiter dictum, and it has no binding effect for the purpose of judicial precedents. So how does Goodhart define ratio decidendi? Goodhart used a mathematical formula. He said the ratio decidendi of a case is material facts of the case plus the decision thereof. Fact in dispute plus decision on the facts. That is definition of ratio decidendi. Okay. Definition by case law. Cases define ratio decidendi as any rule of law expressly or impliedly treated by the judge as a necessary step in reaching its conclusion, having regard to the line of reasoning adopted by him. Okay? So from that we can summarize that the ratio decidendi of a case is either the rule that the judge who decided the case intended to lay down and apply to the facts, or the rule that a later court concedes to him to have had power to lay down. Okay, what do we mean by this? A court pronouncing a judgment might be explicit on the ratio decidendi, but many of the time the court will just go on and pronounce judgment. The body will become that of the judge in a future case. The body will become that of the judge in a future case to decide. It become that of the judge in a future case to decide whether that is right or not. And sorry, to decide what was the ratio. So either of the two can be the case. Okay, it is more difficult for the judge in the second instance, where he has to go through the judgment and narrow down or expand the ratio based on the facts before him. Then the term distinguishing. What does it mean to distinguish? Some of the time when judges are not minded to apply the case you have cited to them, what they do is to distinguish it. You yourself, when your opponent cites a case and you don't want the court to follow it, you can distinguish that case. Distinguishing simply means showing that the facts are not the same. Pointing out that a particular fact that differentiates the previous case with this one, so that the pronouncement in the earlier case need not be followed in this one. Okay? Glanville Williams, you all must have that book, I believe, Learning the Law, taught us that there are two forms of distinguishing. He talked about the non-restrictive or genuine distinguishing, and he talked about the restrictive distinguishing. Okay? You can attempt the assignment I gave you there if you have mastered what we are saying. And I asked you a question there. I gave you a case. The Supreme Court in that case distinguished some previous cases in arriving at his decision. And I'm asking you, what manner of distinguishing did the Supreme Court do in those subsequent cases? Okay, then what is obiter dictum? The plural of obiter dictum is obiter dicta. Statement, by the way, statement that even if the judge had not made them, it will not have affected the judgment. And obiter dicta is, it can be answers to hypothetical question. Answers to hypothetical question. What is this case that I used to illustrate obiter dicta? Yes. In your law of contract, they've taught you I3's case, haven't they? Oh, no, this is first semester. Yes, they ought to have taught you. Under consideration, deduction of promissory estoppel. Have they taught you I3's case? Hello? Hello? Hello?
Hello, sir.
Have you done I3's, the case of Central London property and I3's house limited, something like that? Otherwise known as I3's case, under promissory estoppel. You've not read it. Hello? Am I still with the class?
Yes, sir.
Yes, sir.
Okay, go and read
Sir,
that
the
case.
question is not on it.
Eh?
I didn't hear you, sir.
Okay, I normally use that case to illustrate what is called obiter. You know, the great Lord Denning was the one who decided that case. Now, what happened in the case? It was a case of the lessor agreeing to accept half the rent during a period of war. Okay? And when the war ended, he now sought to move back to his pre-war position of recovering the full rent. Okay? But the tenant had the audacity to say that he remained bound by his agreement to accept 50% of the rent. Okay? Now, Lord Denny's simple decision, simple task was to decide whether the lessor remained bound by his decision to accept 50%. He answered the question, no. Okay? But he said for himself another question. What is that question? The question was, assuming the lessor had insisted on collecting the missed 50% for the period of the war. The war went on for 5 years. Okay, I think 1939 to 1944 or something. I'm not too sure. Assuming he had asked that he wanted his 50% because he was not bound by his agreement. You know, that was not what the lessor asked for. The lessor simply said, look, war is over now, economy has returned, the basis for my making a promise that I will accept 50% is no longer there. Please, henceforth, pay 100%. The tenant said, no, you have agreed. I am going to stick to the agreement we made and all of that. And so the court answered the very simple question before it in the negative, that the man was not bound by that decision, especially after the war has finished. But Lord Dennis set it for himself a new question, which is, assuming the man had asked for payment of his missed 50% for the 5 years of the war, what would have been my answer? That answer that Lord Dennis gave is what you are studying today as promissory estoppel. And Lord Denny answered that question by saying, well, he would not have been able to do that because he will be stopped from doing it, having caused the other party to rely. You know, if I'm the lessee of a house and the rent is becoming too high for me, what do? I leave. So I will promise that you will accept that you will not be able to do it. So in the context of the fact, that question did not arise. It was Lord Denny setting it for himself in order to make the law clear. So that decision, that Lord Dennis decision, which everybody follows today, is itself obiter dicta because the facts did not arise. That's one good example of an obiter dicta. It also shows you that obiter dicta does not mean that, well, it's not binding, but it doesn't mean that it is of no value. Okay? So what are other examples of obiter dicta that we have given? Chance remark, part of the ratio that makes it too wide, that's restrictive distinguishing, ruling on hypothetical facts. But there are cases that have decided, there are cases that have decided that even if it is obiter dicta, if it's coming from the apex court, lower court are not under, they are not at liberty to disregard it. Okay? What is a par incuriam decision? A decision is said to be par incuriam if it was given in ignorance of existing precedent. Okay? But who declares the decision par incuriam? It is said that the court cannot declare the decision of a superior court par incuriam, but the superior court can declare a lower court decision par incuriam. Okay? Also, a court can declare its own decision par incuriam. We have seen now, right from the decision in Young and Bristol Aeroplane, we have seen that the English Court of Appeal can decide its own decision par incuriam. But you will never see a Court of Appeal declaring a Supreme Court decision par incuriam. Okay? Well, the article I showed you there is an article on conflicting decisions. If you read that article and you read that of Professor Iwo, you get the gist we are saying. Okay? But I think that on this note, I've covered what you need to know on style decisis. Any question? I'm training myself to do this lecture. Cover kata is disturbing me. But it's very important for us to finish our syllabus. Any question? Any question? Okay. Go and read this topic very well. I will give you a test, which will be your CA. Okay? I will give you a test which will be your CA on it by Thursday. Is that all right? Hello?
Sorry, sir. Please, is it tomorrow Thursday or next week Thursday, sir?
Yes, tomorrow is Thursday. Okay, what are you reading? Can't you do it tomorrow?
No, sir.
Okay, don't worry then. Prepare yourself against next week Wednesday for CA based on start decisis alone. I can come anyhow. I can give you just some 20 questions to answer in 10 minutes. Objective. And I can give you a theory question to answer in 30 minutes. It will constitute your CA for the semester. Against next Wednesday. So tomorrow, I last sparing my life, 3:30 to 5, I will cover the other topic, which is internal conflict. So any question? Hello, any question?
Sorry, sir. Please, sir. What time next week Wednesday, sir? What time, sir?
Our normal time now, this time.
Okay, sir. Okay, sir.
So read everything I've given you on side decisis. Okay? Read my references and come and do a test of not more than 30 minutes next week. That will constitute our CA. The implication is that we may not examine side decisis in the exam. We may do it in the CA. Is it clear?
Yes, sir. Thank you, sir.
Yes,
Okay.
sir.
So tomorrow we will do internal conflict of laws. That one is also there in this note. If you check it, maybe it's the last one. You can read it ahead so that we'll go over it when I come next week. When I come on Thursday, you say Thursday is 3:30 to 5. Okay? So if
Yes,
there
sir.
is no question, we can go. Thank you very much for attending.